Hello and welcome to episode 2, series 3 of the Harney's Take 10 podcast. I'll be your host. My name is William Peake. You'll have heard me on the original episode 1, series 3, and now I've been entrusted with the microphone today as we are going to delve into the workings of the Judicial Committee of the Privy Council. And in order to do that, I've invited 3 very special guests, inverted commas, guests, colleagues. So we have Deirdre MacNamara and Francesca Gibbons, who are both counsel in our London office.
Hi there.
Hi, hello.
And Joshua Shuardson-Hipkin, who is an associate in that team.
Always the one with the long name. Hello, Will.
There was some significant practicing involved there. I have it written out phonetically so I don't screw it up. So it's 2 Irish versus 2 English, which I hope will be a precursor to some Six Nations success in a couple of weeks. Moving very swiftly on from the topic of rugby. Josh, why don't we kick off with you first? Do you want to just give us a sketch of the Privy Council, what it does, what it is, how it's evolved and where it's got to now?
Yeah, thank you, Will. The court itself has an absolutely fascinating history, and its roots can be traced all the way back to the Norman times, where, if you like, people could take their petition to the monarch about a particular issue and ask for a decision to be made about a particular matter. So it conjures up this lovely old image of somebody trotting off on a horse with their petition and the monarch granting it or refusing it, like you see in films. However, obviously the monarch is a very busy person, and so in time it was decided that he or she would act on the advice of his or her Privy Counsellors, and even today they're collectively known as a formal body of advisors to the monarch. So the idea being that they create advice or give advice to the monarch, who then decides on whether to follow the decision. Now, as time went on, the court's influence grew, and in the 1920s it was thought to be the final court for 1/4 of the world's population. So quite a staggering statistic there, thinking about the number of people that were subject to its jurisdiction. In terms of where we are today, obviously its influence has declined somewhat, but it still remains the final appellate court for many of the overseas territories, and it remains in London, just off Parliament Square, in a beautiful building, which is a wonderful place to visit if you are in the area.
And you can actually, if you can't get down to Parliament Square to see this, all of the proceedings are live. You can watch them.
Yeah, that's right. In fact, most English and Wales courts, whilst you can sit in them, you can't watch them, albeit on television or online. But this court is very different. You can go online and you can see all of the historic decisions, and you can watch the proceedings live, which is wonderful.
I've watched quite a few of our cases there, usually because some vain individual who we work with has alerted us to the fact that they'll be on TV. But it does work extremely well. And just going back, Josh, to the point of the monarch actually approving this order, how does that play out now? Do they still pay lip service to that, or how's that demonstrated now?
Well, the thing I would start with by saying is often proceedings are, any legal proceedings, you have the title of the court at the top of the document. And one thing that I really like about matters before the Privy Council is it actually says at the title of the document, "in the court at Buckingham Palace." So whilst what exactly goes on remains a bit of a mystery, the particular piece of advice, because that's how Privy Council judgments are made by way of advice to the monarch, are taken to Buckingham Palace. We understand a meeting takes place once every 6 weeks where a particular piece of advice will be presented, and the king or queen will always approve it, but nonetheless it still takes place, as if it were back in the Norman times, so to speak.
Yeah, it's fascinating. And it's hard to believe that, you say, in the 1920s, 1/4 of the world's population was subject to the jurisdiction of this court. Imagine how many people would have listened to this podcast in the 1920s. I think it would have definitely put us to the top of the iTunes charts. Josh, thank you very much for that. Francesca, turning to you, you're obviously an experienced BVI litigator. You've lived and worked in the BVI, and you're now based in our London office. And a healthy chunk of your practice is actually Privy Council based based. Do you want to just talk us through some of those cases, the role that we actually play in them?
Yeah, sure. So we've been involved in many big commercial heavyweight disputes where the Privy Council is the last appellate court, and the type of stuff that you'd expect offshore. So shareholders disputes, fraud, trust disputes, and sometimes with a background of insolvency proceedings as well. Some recent cases that come to mind are actually Deirdre's been on the case of Convoy, which is a really interesting one on the BVI's jurisdiction to grant freestanding freezing injunctions. So very interesting and topical area for BVI. Others that we've been involved in very recently are Eurochem and Ning, both of which we won, and some others I've been involved in as well are Bayers and Chen, and also Starray. So hopefully all household names for offshore practitioners. So we're involved in some really interesting cases, and we can appear either as offshore lawyers, or we can actually take the role, if the client specifically asks, of a Privy Council agent, which is a bit of an old-fashioned term, but what it means is having a specific role where you're responsible for dealing with the registry and dealing with filings on a case. And so we can do that as well from London.
So does the Privy Council agent role, does that explain when I have sneaked out for a run during the afternoon in the London office and I come back and there is a hive of activity over the photocopiers? That's usually to deal with the Privy Council filings.
Yeah, absolutely. So having an office in London means that we're very close to the court. It sits in Parliament Square, so we can take charge of the filing and sort that out. And it's a good thing we're very close, actually, because there have been all sorts of dramatic events in the past few years, including blockades and rallies, and obviously we can account for all of that. I recall there's one event actually where I came out of court and thought, am I seeing things? There are literally 300 black cats. And it just so happened that all of the taxis were on strike and decided to do it outside of the court. So those kind of course, I can get those kind of things you have to prepare for.
I suppose just as well you'd booked an Uber in advance. And we'll come back to this with Deirdre, because I know Deirdre's going to touch on the impact of COVID and the electronic filing bundles and how we may actually be the death of the photocopier and a much more pro-green approach, which I think we'd certainly love to see, and we'd really encourage that. I mean, just in terms of how the court operates, and I appreciate we sit on a court users group. Well, what does that actually mean in practice?
Yeah, so Josh actually sits on it, so I might ask him to come in at this point. But this is a really useful function for us, because it means that we have a direct line of communication with the court, and it's a two-way process. So it's an additional thing that we can offer input into.
Yeah, Josh, what does that look like on a kind of day-to-day basis?
Yes, so we're fortunate to be a member of the JCPC user group meeting. So that's its official title, which is actually chaired by Lord Hodge, who's the Deputy President of the Supreme Court. And that meeting is attended by all of the key Privy Council agents, and it's a chance for everyone to put forward particular matters concerning how things are going, where they would like to see certain improvements. So in the most recent one, there's obviously the usual COVID update, which everybody has at the moment. But then we spoke a little bit more about timetables and filings and procedural matters, things which can cause you big headaches in practice, but it gives you a chance to say to them, actually, we'd like to change this, we'd like to change that. And of course, it's considered by the registrar and the chairman, so you get to put forward your point of view for consideration straight away.
Yeah, and I presume that the golden thread of everything that everybody in the financial services is doing at the moment is the impact of COVID and how that has made business more challenging, but has also presented innumerable opportunities to streamline business. And I do think that as offshore lawyers and people who've on occasions lived in a remote world to facilitate clients and to essentially actually respond to the kaleidoscopic global nature of clients and service providers involved in complex cross-border litigation, we've been ahead of that curve. And Deirdre and I have spoken at length in the past about how we might be better placed in that regard. What are you seeing, Deirdre, in terms of the evolution of the Privy Council in that respect of how it's doing its business in a COVID world?
Yeah, what I've seen is the Privy Council has just adapted so quickly to to what's happened in the past year. Very quickly we had a temporary practice note issued dealing with how you contact the registry and how you file documents, remote hearings, judgments and orders. So for example, all hearings now are held virtually and all filings are electronic. So there's no hard copy filings unless you're specifically requested. And, that's been a revelation really when you consider some of the cases we're involved in with bundles in excess of 15,000 pages. And what we've seen in the last few hearings that we've had in the past few months is that all of the panel are using electronic bundles exclusively. So there are no more hard copy bundles, and it works really well. Counsel will call out a page number and the board will be able to just type in that page number and it comes up instantaneously right in front of them.
Hey, presto.
Yeah.
And did the practice note give any guidance on how to put a cat filter on counsel's face? Because I think that's really important actually to get that right. Just in terms of trying to move on as quickly as possible from that terrible joke.
No, I think that Josh should raise that at the next user committee.
Exactly. Josh, you have been tasked. We'll leave that in your capable hands.
Yeah, I'm happy to put it on and use it as a bad example. I'm sure that will go down very well.
Perfect. We look forward to your update on the next podcast about that. Just in terms of kind of any tricks and tips, Deirdre, for the remote hearing with the Privy Council, because my understanding is it's only leading counsel who's addressing the court. So it's not instructing solicitors, junior counsel, they don't. So presumably there's a lot of scurrying in the background to try and recreate the virtual world of a courtroom. How do you get the post-it up to the leading counsel so that he or she can actually make the point that has occurred to you or occurred to the client? What kind of tips and tricks do you have there?
Yeah, it's very much a team kind of consideration how you want to deal with it at the hearing. And I mean, it really depends on the matter and counsel's preferences as to how they want us to communicate with them on the day. In a recent case, a counsel requested that we set up, an encrypted messaging system for us to pass on instructions during the breaks so that, that he could read those and be able to pick up on those. We find as well that the panel itself is very accommodating in terms of providing more frequent breaks, given that there's, no client in the room or no instructing solicitor in the same room as counsel. So that's obviously a great benefit as well. It really depends on, the circumstances, but it's worked really well, I think. But you're right, yeah, the leading counsel only is permitted to attend the virtual video conferencing facility. I suppose it just keeps the group small and maybe minimises any technical issues that may arise. But the registry is very, very organised in terms of IT as well. So there'll be a run through a few days before with counsel of their IT systems to make sure everything is working fine.
Yeah, because I do think this isn't a Privy Council observation, but I do think the world of remote hearings, I think there's some real challenges in terms of, in the run up to a physical hearing, the industry that is involved and the pressure of actually being in the room with the opposition sometimes causes decisions to be made and a whole new dynamic that I think is lost in a remote world, because you don't have those pressures. You don't have a situation whereby your client has to walk past the opposition, and all of that tension is lost. And I do think in years to come, there will be some kind of interesting statistics on cases settling, whether there have been interim hearings taken from a pure strategic perspective to cause a logistical nightmare for other sides. But I think that's probably for another podcast. Conscious of the title of this podcast is Take 10, I think we should wrap it up there. But thank you very much, Josh, Deirdre and Francesca. That was really, really interesting. And certainly, I think I'm well versed for my Zoom quiz this weekend, and really hope that Privy Council comes up as a topic amongst top goal scorers of the 80s, because I think I've got some answers for the questions. So thanks very much, everyone. The next episode of Take 10 will be released next month. I'd encourage you all to subscribe if you enjoyed listening to this. And please do feel free to reach out to us if there's anything we can help with. So thank you very much. Really appreciate it.